Welcome back to the concluding episode of our comprehensive series on the Nevada Incomplete Gift Non-Grantor Trust, particularly in the face of California's new tax law enacted in July of 2023. Over the course of our previous videos, we have delved deep into the intricacies of NINGs, from the conceptual introduction of completed gifts to understanding their consequential outcomes. Today, in this fifth and final installment, we turn our attention to one of the most pivotal aspects, preparing you for those all-important client meetings involving a NING. We recognize that being equipped with the proper knowledge can make all the difference, and we aim to ensure you step into those discussions with clarity and confidence. Let us listen to this final chapter with Jeffrey Dunham, founder and CEO of Dunham and Associates, and Ann Rosevear, the president of Dunham Trust Company.
So, Ann, let's make sure that our financial advisors are prepared for the meeting with the client.
Right.
So, client is, I want you to summarize because you have great thoughts about this sort of thing. So, client says, I was at the club and I heard Newsom signed this thing, and it's scary. I don't understand how this affects me and my estate structure, and I spent a ton of money and a lot of time putting it in place. How should the financial advisor prepare for that discussion?
So, first of all, look at it head on. The client needs you to act now because their question is, what's going on and what do I do? So some concrete thoughts on that. Number one, as their financial advisor, know their 22 tax situation.
22.
22.
Okay.
That has passed. Hopefully, if it's filed yet. Know what they paid in 22.
Okay.
And from that, look at 23 and be ready to talk. Maybe you have to talk to an advisor first. Be ready to talk about the difference that is going to occur in 23.
Because of this new law.
Because they no longer have an NING structure to rely on for state income taxes. So that question right there goes back to our conversation about whether you have a scratch or an amputation or something in between.
So quantify the pain in terms of dollars. How does this dollar-wise likely to impact you in 23?
Right, because there's so much noise around this. Get down to that situation. Did 22, what was 22, what is 23 likely to be because of this legal change, because of this regulatory change?
Because the change could be this much, or the change could be this much.
And if the change is zero, because their ING that they were talking about has nothing to do with their personal portfolio, right?
Which they may have forgotten.
Which they may have forgotten because of all the issues we talk about. So number one is, what did 22 look like? What do you think 23 is going to look like? Is it zero or is it amputation?
So that's number one.
That's number one. Number two, if it's amputation, you need to get used to that, right? You need to start working on that side. Well, let's say it's zero. If it's zero, the next question is, when is it going to start to hurt? Is it that Q4 exit? Is it in 2025? What is our frequency in terms of, do we need to meet now? What's our timing? Do we need to get the advisors involved? Can we sit back and look at this for a moment and say, all right, I want to stop and re-engage the conversation. So, how bad is the injury right now? Is there going to be an injury in 24, 25, 26, to use, back to our analogy? And in terms of that, then when does the urgency start? Is it now? Is it then? Because your client's panic level is really coming from just the unknown. Right. And so if they know...
Does this affect me?
Does this affect me?
If so, how does it affect me?
Right.
And what can I do about it?
So those two questions, really, are what the advisor might have to gather a little bit, get access to CPA, whatever it is. But if the advisor can answer those two questions and be ready to answer them in the first 5 to 8 minutes of the conference, then the client's head is going to clear and we're going to start talking about future planning.
Then they'll actually listen to the rest of the conversation.
Right.
So, number one, measure the dollar impact that this law is going to cause, and two, measure how does it affect really 23, which is staring me in the face.
Right.
How does it affect me in 23? And then you what
And
about the control issue?
Yeah, if it doesn't, then if it's a 24 or a 25 or a 26 issue, then let's start talking about what's your relationship with this trust, how do you feel about control, right? And are you ready to talk about the things that you give up a little bit more control so that that number that's going to occur in 24, 25, 26 has a better impact, right? So the control issue, again, it may be a different myriad of various types of trusts. We're not expecting an advisor to go down that road, but we do want to go in and say, how do you feel about the relationship these last 3 years in this trust? How do you feel about the trustee? How has it worked for you? Are you ready for this team? Are you happy with this team? Because this team has some ideas. They're going to involve giving up a bit more control, maybe planning out for kids, but how do you feel about giving up a little bit more control because we think in 2025 the number we thought would look like this is going to look like this. So let's start meshing loss of control with better financial results. Those answers are yet to be determined concretely. But the first two, what was 22? What does 23 look like? How bad is this hurting? You should walk into the meeting knowing that.
I think that's excellent advice. So know the financial impact in terms of dollars, know the timing of that financial impact,
right.
And that's going to allow the client to breathe, to listen, to quantify, and then they would be willing to consider other options. I had the privilege of talking about this NING concept 2 days ago to a Tiger 21 group. Let's just say a group that is a large consumer of these concepts. I drew something on the board that was very helpful to them. So the financial advisors that are listening to this might find this useful. To that group, I said, your lawyers, your trust companies, your insurance professionals, your financial advisors, your CPAs are going to throw a lot of terms at you, are going to have lots of boxes and circles and arrows. They're going to talk about distasteful things like dying and taxes, and it's not something that is fun, and it's not something that you deal with every day. It's in your day-to-day business life or your day-to-day personal life. But the way I suggest you, ladies and gentlemen, think about this is the following. In terms of a vocabulary lesson, in terminology, whenever they are trying to go after an income tax discussion to save you money on income tax annually, they talk about the concept of grantor versus non-grantor. And so I wrote on the board, G and NG. When they use those terms, G or NG, grantor or non-grantor, the focus of the discussion is centering around income taxes. So grantor, you have the income tax still as the client. Non-grantor, the income tax is somebody else, some other entity. The other two phrases they use commonly is complete and incomplete. And when they use those terminologies, the focus of the tax is estate taxes. So it's not an annual thing that they're talking about. They're trying to help you save the 40% tax hit on your estate, which is your net worth, that is above whatever the exemption is. Whether the exemption is $5 million or $25 million or $2 million or 22 million. They're trying to help you save on a one-time thing, and that is the 40% whack that the federal government wants on your net worth when you're dead. So G, NG, grantor, non-grantor, the focus is income taxes. And that's an annual benefit that they're trying to focus on. Complete, incomplete, the focus is estate tax or inheritance tax. And it has nothing to do with an annual savings. So if you get those four phrases, grantor, non-grantor, complete, incomplete, you get that vocabulary in your head straight, and I only had to write it down 612 times before I understood, or I could regurgitate. That will make you, that will really help your clients to understand when the lawyers and the other advisors in the room use those words, what that means.
And so, we have concluded our in-depth exploration into the Nevada Incomplete Gift Non-Grantor Trust, particularly in light of California's significant tax law changes. From understanding the initial implications to strategizing the next steps and preparing for client meetings, we have journeyed together through a complex landscape. We hope this series has empowered you with the insights, tools, and confidence to navigate these changes effectively with your clients. We want to thank our experts, Jeffrey Dunham and Ann Rosevear. Stay connected for more insights by subscribing to our YouTube channel and our Dunham blog at dunham.com. Please feel free to call us at 775-826-7900 and ask for our NING hotline, where Dunham Trust Company experts are prepared to help you answer your question on the California tax law changes and work with you on strategies for your clients with a NING. Until next time.